Good morning, everybody. Happy Super Friday. Welcome to the Courtroom Files Live. It's an exceptional day for us here in the TCF bunker. It is our 17th anniversary today, my wife and I. She's sitting with me in the studio, staring at me intently, hoping that I screw things up because that's just how she is. But let's start the day in Michigan, Lenawee County. Judge Anzalone.
Probation violation sentencing on an AG case, Mr. Evans. So that's why I had asked you if you were coming in on that. Usually the AG's office doesn't appear for those, but just in case. So I do have a probation violation recommendation report, and Ms. Dumont, you did receive that?
Yes, Your Honor, we've received it.
Yes, speak up for me.
Your Honor, we've received it and reviewed it.
Okay, so Mr. Klein, you've had an opportunity to discuss this report with Ms. Dumont.
Yes, Your Honor.
And you've been able to ask your questions?
Yes, Your Honor.
Are you satisfied with Ms. Dumont as your attorney and the advice that she has given you?
Yes, sir.
All right. Ms. Dumont, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
No, Your Honor.
Okay. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Klein?
Your Honor, Mr. Klein, since he got picked up and has been incarcerated, has been open and honest about his relapse, about his violations, what was happening, and the new charge that he's got as well. He did advise me he has a place to stay upon release, employment as well, so he can start paying on his fines and costs. At the plea hearing, Your Honor said that you had a plan for him. I guess we were both wondering what that plan was. We see the recommendation is for credit for time served with all of the files except the, I believe, 23-21225. But all of his guidelines are relatively low. They're just a 0 to something. So I guess we were also wondering, I know it indicated give him 1 year in the county jail with credit for time served on the 2-3 file, max out on everything else. I guess we were wondering what his possible sentence would be if on the 2-3 file he elected to max out as well, seeing as he's almost served a year and he's got 0 to 17 months initial guidelines on that. So I guess we were just looking for some clarity from the court so he could then make a decision and confirm with you on what he would like to do.
All right. Mr. Klein, first I will say that you have always been extremely candid and understanding of the issues you have with addiction. Your life has been kind of a roller coaster because of it. You suffered great losses because of it. But, you know, I know that you continue to want to get past it. But is there anything you'd like to say on your own behalf?
I was 8 months sober this time. I know it's not a good excuse. My reason, I was supposed to talk to my kid and I didn't get to. And I filed a thing and I decided to press. I went where I went. I met a wrong girl and I lost my job and just like it's tumbled. I worked really hard to see him and I didn't get to talk to him. I lost it for a minute. Yeah, I mean, I had 8 months and I did it. Like I was really good. It really was. I've been trying. I did like 90 at 90. I was going like 5-6 days a week. I was killing that. I really want to be done with it. It doesn't do nothing for me. It's messed up. I ended up getting Hep C, not even like through a needle, like physically getting it like an STD. I'm sick from it still. I'm done with this life. I really am trying.
So, Mr. Klein, I know that you love your child, but until this gets figured out, you're not good for him right now. And, you know, the constant relapses and going back and forth are not healthy for a child. So, I mean, you got to fix you. And, you know, one of the things I always say is boyfriends and girlfriends are not good when you're in the throes of addiction, right? So you got to fix yourself and get to a place where you can have healthy relationships. So is rap available to him?
I'm not sure.
Mr. Moore, I'm sorry, I just look at my,
Oh, I don't have the answer to that. I wasn't thinking about rat for him, but that would be.
so his guidelines on one are 0 to 9, 0 to 11, and then 0 to 17 on
Mhm.
2-5. And on 2-5, he has credit for 267 days, which would allow for the RAP program.
Okay. Well, if I don't see any reason he wouldn't be eligible. I mean, he does have a new felony coming up for retail fraud here.
Oh, do
So
you?
he was he was released from jail and committed a retail fraud, and so he is facing that coming up. He's been arraigned on it. Also, he will have a probation violation out of Monroe County with this new retail fraud because he has a case out of Monroe County. So it's a little bit, complicated right now. So, if he was locally in jail, he could maybe on the new retail fraud case that comes through, a RAP program out of that, would be probably a better idea.
I thought I could only send RAP on a violation.
Oh, okay. Okay. Well, then, yeah, I mean, if you want to postpone
Does
this
he
and
have
want
a
me to
court date?
look
Do you
into
have a
RAP,
court date on the retail fraud?
And we have, an arraignment on it, I believe, on the 24th. We have an arraignment on
Next
that,
week?
next week, yeah. And we do have an offer in that from the prosecutor, where it was, he could plead, as charged, no subs with the first 6 months in county, or, as charged with the second sub, no sentencing agreement. So we could try to work that out.
Miss Adams, do I have October 2nd, 3rd, 9th, or 10th available?
October 3rd is good.
Set this over to October 3rd to see what happens with his new file. So we'll adjourn this to October 3rd at 8:15. You want to be here in person, Mr. Klein? Okay. All right. So we'll see you back on that day. Thank you.
thank you.
So good morning once again, everybody. Happy Friday. Welcome to the Courtroom Files Live. It's good to have you all here today. Let's go to Florida. Let's check out Brantley Clark. We haven't been there in a couple of weeks. Let's see what's going on with him.
It's only count one, accessory after the fact, which is a significant reduction in terms of what the pending charge is now. And therefore, we're asking for a bond reduction that would be commensurate with the reduction in the charge. It went significantly on the numbers, quite different. His score sheet, which was an amended score sheet, and I don't know if the court got the amended score sheet or not. I have a copy that Frank sent me. The amended score sheet, lowest permissible, is 44.100, lowest permissible. The maximum is 25 years under the accessory after the fact charge. So number one, I'm asking for a reduction so that whatever bond the court requires matches the reduction in charge. I'm also advising the court, I mean, I can put him under oath if you want me to on that. I'm sorry? Yes, sir. I'm sorry.
extensive history, please just believe that the bond is proper at this time. He has a manslaughter charge out of Alabama and 2 counts of grand theft of motor vehicle, 1 count of grand theft of a firearm.
Thank you, Judge.
We need another court date for Mr. Williams.
Go to 23 for trial.
Or we'll just leave it there.
Very well. Thank you, sir. You can have a seat. Judge, I have one more case.
All right, you can call it.
Abigail Tillery, Tillery. Case numbers are 25-1859 CF and 25-126 CF. That last one is a VOP. Judge, I filed a request for competency, and my understanding is that has been accomplished. I'm not sure I have all the results from that, but
Notice the service of evaluation. I got a copy of it.
I do, sir. I have one, and this is, you got it?
I have the instructions for Mr. Sullivan. That's
Right, Mr. Sullivan has a copy.
Mr. Sullivan did review it.
Yeah, that is the recent,
Let me review it real quick.
yes, sir.
I don't think I got a copy of it.
It's very fresh. It's very recent, so that may be explaining why.
It is. It was ordered on the 22nd. Dr. Rayleigh, we'll see how before this, but his timeliness is good. No, I have reviewed it.
I'm sorry, what, Judge?
I haven't. reviewed it.
Ashley gifting 10 memberships. Thank you so much. And we successfully targeted our Polish friend for that. And Glenn got a gift membership for like the 3rd time. He's got connections at YouTube, I think. That is like the 3rd time he's been gifted. So congrats to everybody. And again, thank you, Ashley. Really appreciate that.
Mr. Sullivan asking for another expert? No. Mr. Peacock, you've reviewed this, is that correct?
My understanding is he did.
Now, you've reviewed.
Oh, yes, I've read it.
Are you asking for another expert?
I'm not asking for another one.
Any objection to me accepting Dr. Rayleigh's report and finding Ms. Tillery incompetent to proceed in the least restrictive measures available is in Florida State Hospital?
No objection, Your Honor.
Okay, that's what I'm gonna do today. Mr. Peacock, if you'll prepare that order, and I'm gonna find the least restrictive measures as inpatient treatment at the care of Children and Family and Human Services. Whenever she's restored to competency, we'll bring it back, okay?
Very good. Thank you, and thank
For
you.
the record, I like Dr. Rayleigh's report.
Yeah.
I like his timeliness. He got this order on, with the order was, I signed the order on August 22nd. And by September 16th,
Yeah,
there was a report filed or a notice of report being provided. So who's ever copied that is, y'all remember that. And Ms. Nelson, if you'll remember that too, I wish all our experts were that timely and had that, and that kind of report that makes sense and you can read it. So, all right.
I agree, Judge, and I'll probably ask for him again in the.
Well, we have to do it by who, I think we're supposed to.
Gotta
do
be
it.
that check.
Whoever's on the next spot, but
Right, and he was on the checklist.
yeah, oh, yeah, yeah, he's, You did a good job.
All
All
right,
right, Mr. Turner, you ready? Mr. Peacock, have a good weekend.
thank you. Now you have a seat. You're going to go with him. You're going to go with him. Thank you, Judge.
Thank you.
Morning, Judge. Joe Turner here for Wasana Carter. It's 25114 CF. Her restoration treatment is ongoing. The monthly update that was filed indicates she's attending weekly. She's keeping in good contact with my office. And so her treatment continues.
That's all I ask.
All right. So, I don't know, a couple months.
Yeah, let's set it for November 21st at 9 o'clock. So where we're at.
Sounds good. Thank you very much.
Have a good weekend.
You too.
Mr. Graham.
Step forward, Mr. George Myers.
Ms. Piazza.
Morning, Judge.
Good morning.
This is George Myers, 224840, 224842. We currently have him set on October 6th for trial, and I believe we're still ready to move forward.
Okay. All right. And y'all know, I don't know if you talked to Mr. Sullivan, but I'm out that Wednesday.
I'm
I'm
sorry.
out October 8th. I'm gonna pick juries and try on Tuesday, Thursday, and Friday. So I know Mr. Sullivan has been scheduling that. I don't know if, I know that he knows that Mr. Myers is set for that week. But they just for y'all's information. How long do we expect this to take?
There's going to be two experts, Judge. You know, what I think is a day and a quarter. I mean, what I can
Okay.
see is us finishing up and maybe closing the next day or something.
Okay. All right. Well, just when Mr. Sullivan gets back, y'all coordinate that week for all the trials. I got some speedies that week too, I think.
Yes, sir.
All right. Thank y'all. Mr. Myers, that'll conclude today's hearing. Ms. Piazza.
Judge.
Ashley throws down a $20 super chat. Happy anniversary, Mr. and Mrs. TCF. Thank you so much, Ashley. Really appreciate that. Maybe we'll buy some ice cream to go with our clearance ravioli tonight. Have dessert. That'd be fun. Let's change it up a little bit. Let's stay in the 14th Judicial Circuit, but we're going to go to Judge Anna Garcia, who is actually handling first appearances this morning.
First appearance this morning. Ms. Smith, good morning.
Good morning.
Ms. Smith, you have a loved one here in the courtroom. Sir, do you want me to tell her who is appointed to represent each and every one of you for purposes of first appearance this morning? Ms. Smith, good morning.
Confirm that
Good
you
morning.
have that appointment.
Ms. Smith, you have a loved one here in the courtroom.
Mute whatever you
If want
have.
me to
It's
tell her
playing
who
again.
is appointed to represent each.
You want to email it to me?
It may not be Stephanie.
Bring it by.
Pamela, if you can hear me and you see someone's audio going off, if you don't mind muting them, that would be great.
Okay, yes, sir. You can take a picture of it and send it to my phone. He needs to see something before he will consider rescheduling.
Stand by, peoples. We're having technical issues. I'll let her know.
Incriminating evidence.
Yes, sir. It's
Sorry, Stephanie. I don't know why your box lit up.
Because she's the only one that's showing.
0900.
Yeah, it's fine. We'll just give her a minute. It sounds like she might be on the,
89.
that her audio is still on.
Sorry, Stephanie. I don't know why your box lit up.
Thank you. Bye-bye.
Just give her a second. Hey, Pam, if you can hear me, this is Judge Garcia.
Yes.
We think that you may not be muted. Would you mind muting?
Okay.
Thank you.
That's what we
Okay.
just heard.
All right. Ms. Smith, your husband is present here in the courtroom, okay, on your behalf. Ms. Smith, you have been charged with the following. You have been charged with one count of grand theft, more than 10, less than 20,000. That is a third-degree felony, punishable by up to 5 years in prison and or $5,000 fine. You have also been charged with one count of cashing or depositing an item with the intent to defraud, also third-degree felony. I have reviewed the probable cause narrative and a judge issued a warrant on those issues. I do find there is sufficient probable cause for those charges. Ms. Smith, are you on probation anywhere?
No, ma'am.
Do you have any pending criminal charges?
No, ma'am.
Ms. Smith, it's actually my understanding that this is your first offense. Is that right?
Yes, ma'am.
All right. Councils, I am considering giving two options, or actually three options, monetary bonds in two of the options, or non-monetary bonds. Does anyone wish to be heard as to potential release options?
We'll see what John says first and I'll let you know.
Or do you have any objection to a non-monetary
Oh,
bond?
no, I have no objection to a conditional release if she chooses that.
Sure. So John, John, what I'm looking at is either a conditional release or giving her two bond options. The standard bonds on third degree felonies, or a cash bond if she wants that, to help her not have to waste the money with, not waste, but not have to use money that then won't come back.
Judge, she was indicating to me that she wishes to choose a conditional release.
All right, fair enough. So ma'am, Ms. Smith, I
Yes, ma'am.
am going to give you a conditional release. Those conditional releases will have various conditions. You will be instructed as to those conditions when you come to the Jackson County Courthouse later this morning. You are ordered not to have any contact with, it's Tyndall, right?
No.
It was the bank, whatever the bank was. You are ordered to have no contact with the bank. Ms. Smith, it is very important that you not violate the law if you are out on conditional release. If you are alleged to have violated the law while out on conditional release, then the court will hold you without bond pending resolution of this case. Do you understand so far? And do you have any questions for me?
I understand, and no, ma'am.
Okay, fair enough. Anything further on this case, Mr. McDaniel?
Do you want to set her on that October 7th docket?
Yes, thank you. Ma'am,
But
I
I get
will
out.
have you come back to
Okay.
court. Yeah,
Yes,
I'll
ma'am.
have you come back to court. It's going to be felony court with me on October the 7th. Your court date will be the time will be 9 a.m. on October the 7th, okay?
Okay.
All right, I will see you then. Mr. Mitchell, anything further on this case?
Just to put on the record that the bank was First Commerce Credit Union.
Got it. You may have no contact with any First Commerce Credit Union in the interim.
Yes, ma'am.
All right, well then, if there's nothing further, Mr. McDaniel, husband, do you have any questions? She will be transported here, right guys, still? Is that how that happens? She will quickly be transported here. She will be at the Jackson County Judge's office downstairs, and you can meet her down there. All right, but Mr. Stacy will maybe give you more info. Mr. McDaniel, whenever you're ready.
Melissa Bonaventura.
Thank you, sir. Ms. Bonaventura, good morning.
Good morning.
Ma'am, tell me your full name for the record.
Melissa Bonaventura.
Ms. Bonaventura, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right, Ms. Bonaventura, you have been charged with the following. 1, third-degree felony count of grand theft motor vehicle that is punishable by up to 5 years in prison and/or a $5,000 fine. You have also been charged with 1 count of fleeing or attempting to elude law enforcement with lights and sirens, also third-degree felony. I do find there is sufficient probable cause for those charges. Ms. Bonaventura, are you currently on probation anywhere?
No, ma'am. No, ma'am.
Do you have any pending criminal charges?
No, but I just came from Gadsden County for 45 days, and then I came here. They transported me. No.
Okay. So you had a charge in Gadsden. What happened in Gadsden?
Well, when I was fleeing and eluding that FHP, what, you want to say something?
No, I'm thinking she may have been charged the same charge in both counties because
In both
they arrested
counties?
her. Yeah, that's what I'm anticipating is going on.
Did
Yes.
she resolve the fleeing and eluding in Gadsden County, or is that still pending?
I mean, they released me.
Did you find out?
No,
Just,
I-
I'll
no,
double
they
check.
transported me yesterday. I was there for 45 days.
All right. So, Mr. Mitchell, if you will please let the felony prosecutor know that she may have been charged for fleeing in both counties, just so they're aware, so that they can make a decision regarding the charging here in Jackson County. Ma'am, the last charge you had here in Jackson County was an armed trespass in July of 2025. Is that right?
No, I was not armed. It was criminal
Okay.
trespassing.
All right, fair enough. But you served 10 days in jail. Is that right?
Yes, ma'am.
All right. Anything further, councils, before I proceed with announcing her release options?
Your Honor, she did have a felony case in Gadsden County for fleeing and eluding and DWLSR, but they transferred it to county court and I guess dropped the fleeing and eluding over there. So she does have an open DWLSR case in Gadsden County. So
Sure.
that's
Thank you.
why she's here today.
Sure. All right. Thank you. That makes sense. Anything further from the state or the defense?
Nothing else.
No, Your Honor.
All right. Ms. Bonaventura, I am going to set your bonds in each of these charges in the amount of $10,000. It will be cash or surety. Ms. Bonaventura, if you make those bonds, you may not operate a motor vehicle without a valid driver's license. You may also have no contact with the victim of the grand theft motor vehicle. Do you have any questions for me about your release options?
No, do I have any conditional releases or no? Just bond?
No, you
okay.
are not. Yes.
My license wasn't suspended, it was just expired.
No question, John. We appreciate it.
Thank you.
Okay, Ms. Bonaventura, I will see you, John, if we can let her know about her next court date.
October 7th at 9 o'clock. Yep.
Yep, October 7th at 9 o'clock is your next court date. Danny Pelham?
Your Honor, did you get the email I sent about him earlier?
Y'all, I'm not good about reading emails or texts before first
She's the
appearance.
same thing.
So you just let,
so just
Yeah.
bond. We just-
yeah, I mean, you guys, I'm happy to hear whatever you want to tell me in court, but I genuinely don't look at that kind of, I review the paperwork. So if you want to tell me something, tell me in court because I don't generally have.
I was going to give you an update from
Sure.
what me and Mr. McDaniel have talked about, but I think he's going to say it.
Okay, fair enough. Mr. Pelham, good morning. Tell me your name for the record.
What's your name?
Danny Darrell Pillar.
Yeah. Mr. Pelham, did you understand the rights that were explained to you on the first appearance video?
Right.
Okay. Mr. Pelham, you have been charged with one count of trespassing. That is a first degree misdemeanor. Mr. McDaniel, Mr. Mitchell?
We just asked for reasonable bond, Your Honor.
Anything else?
No, Your Honor.
All right, Mr. Pelham, I do find that there is sufficient probable cause for the charge. Based on the probable cause narrative, you were given a trespass by the by the officer allegedly on September the 13th. Because of the proximity of time from that date to now, then the court intends to issue your bond in the amount of $2,500. That will be cash or surety. Mr. Pelham, if you make that bond, I order you to have no contact with the victim or the victim's property whatsoever. Mr. Pelham, if you do, then I intend to hold you in custody pending resolution of this case. Okay?
Okay.
All right. Thank you, sir. Good luck to you.
Good luck to you, Danny. Good luck to you, sir.
Good morning, Mr. Stowe.
Good morning.
Mr. Stowe, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
Excellent. Mr. Stowe, tell me your name for the record.
Victor Paul Stowe II.
Excellent. Mr. Stowe, you've been charged with the following. You've been charged with one count of possession of methamphetamine. That is a third-degree felony punishable by up to five years in prison and or a $5,000 fine. You have also been charged with one count of possession of drug paraphernalia. That is a first-degree misdemeanor punishable by up to a year in jail and or a $1,000 fine. I do find that there is sufficient probable cause for those charges. Is there anything further from either the state or the defense on this matter?
We just
No, Your
request
Honor.
that he be subject to random UAs.
All right, fair enough. Nothing from the defense. Mr. Stowe, are you on probation anywhere?
No, ma'am.
Do you have any pending criminal charges anywhere?
No, ma'am.
All right, Mr. Stowe, I'm going to set your bonds as follows. On the possession of methamphetamine, your bond will be $2,500. On the possession of paraphernalia, your bond will be $500. Total bonds in the amount of $3,000. If you make those bonds, Mr. Stowe, you may not consume drugs or alcohol while you are out on bond. And I order that you be subject to random urinalysis at the court's request. Mr.
Yes,
Stowe, if you use drugs or alcohol while you are out on bond and you have a dirty UA, the court intends to hold you without bond pending the resolution of these charges. Do you understand?
Yes, ma'am.
All right. Anything further, counsels?
No, Your Honor.
No, Your Honor.
Oh, yep. Mr. Stowe, your next
Ma'am.
court date will be October the 7th, 2025 at 9 a.m. If you are out of custody on that date, then you are to get yourself here to the Jackson County Courthouse by 9 a.m., okay?
Yes, ma'am.
Good luck to you, Mr. Stowe. Counsels,
Thank you.
are there any other matters that you wish for the court to consider this morning?
No, Your Honor. Well,
All right, since she's wrapping up, let's do something a little bit different. So normally when we go to Ohio, that's dungeon court, where we know that justice is best served in a dark, dank basement. But that's not the only way they serve justice in Ohio. Sometimes they do it in a really ornate-looking room. You're looking at Lake County. This is Judge Vincent Collada. I have not witnessed his court very much. I've just caught a minute or two here or there. But this is a partially pixelated court. If you'll notice at the bottom of the screen, they blur stuff out. Undoubtedly, that's where the jury normally sits. But let's see what's going on there.
Client is prepared this morning to waive both her probable cause and her final hearing and would respectfully ask to go straight to sentencing, Your Honor.
thank you.
Joseph, you've been charged with violating the conditions of your community control sanctions. Specifically, there are two alleged violations. The first is a violation of Rule 11, which requires you to comply with all special conditions set forth by the court. You were ordered to enter and successfully complete the program at NeoCap, and you have refused to participate in this program. The second violation is a Rule 11 violation as well, condition number 9. You were specifically ordered not to have any contact with Victor Roberts, and beginning on August 28th of 2025, which was after the sentencing, you began having contact with him through phone calls and messages. Now, you have the right to have a couple hearings regarding these allegations. The first is called a probable cause hearing, which is a hearing where the state would be required to present some evidence to suggest you probably committed these violations. You then have the right to have a final hearing on the merits, and that would be a hearing on a different day and different time to give you time to prepare with your lawyer if that's what you needed to do. And that would be a hearing where the state would be required to prove the actual merits of what they're alleging. Now, you could have either or both of these hearings, but you can also waive the hearings and plead guilty to the violations. Your attorney has indicated, based on his conversations with you, he believes that you want to waive the hearings and plead guilty. Is that correct?
Yes.
Before I can accept your waiver and your plea, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. I can impose more restrictive sanctions against you, including an order that you serve more time in our Lake County jail, or I could terminate your probation and send you to prison. And if I did that, in case 25 CR 1124, it could be 6 to 12 months on each of the 3 counts that can be served consecutive for a total of 36 months or 3 years in prison. In case (25 CR 503), it could be 6 to 12 months on count 3 and 4. That could be consecutive for a total of 2 years, and 2 cases can be consecutive. So there's 5 years in prison that you're facing if you're found to have violated your probation. You understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes.
Having been so advised, what do you want to do at this time? Do you want to have either of these hearings? Do you want to waive both hearings and plead guilty to the violations?
Guilty.
Very well then, regarding the first allegation, But you violated Rule 11 by refusing to go to NeoCap. What is your plea to that?
Guilty.
As to the second Rule 11 violation for having contact with Victor Roberts after you were ordered not to, what is your plea to that?
Guilty.
The court will accept your plea of guilty, find that you did violate your community control sanctions. Mr. Williams, Mr. Watson, I'm sorry. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court, I'll be extremely brief. This goes back to what I said at the original sentencing, Your Honor. I believe Ms. Joseph legitimately has some mental health issues. I know she's in denial about it. I know the court had some questions about it at sentencing. I've spoken to her mother several times. Her mother's indicated to me that previously the defendant here, Ms. Joseph, was on medication specifically for her mental health. She's been off of it for quite a while. I am not blaming her actions solely on that, but I do think that that's a root cause of a lot of what's going on. I know she's been a problem in our jail. Your Honor, and I'll be blunt with the court, she's been difficult with me, but I haven't given up on her. I do believe she's a young woman, 20 years old. I think she has her whole life ahead of her, but you know, she's got to get it together. And based upon her request, Your Honor, she wanted to waive both hearings, go right to sentencing. I'm going to respectfully ask the court to take into account her age, her mental health status, and the fact that I don't believe she has any prior felony record as an adult. I'm going to respectfully ask the court to consider a minimum sentence in this case. Thank you, Your Honor.
Thank you. Ms. Joseph, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes. I would like to say that I know that I have done a lot of wrong things, and for this violation, I had a misunderstanding on what I was sentenced to. I'm not using that as an excuse because it wasn't a reason to lose myself like emotionally, but I want you to know before you sentence me that I did apologize to my probation officer, and I told her it was a horrible way to meet her because I know she didn't deserve the way that I had lost myself emotionally. And I also would like you to know that I know that I have done a lot of wrong things, and I know that that I shouldn't have done them, and that I need to be better, and I want to get better, and I want you to know that I want to be a better person, like in general, and I want to learn how to make, you know, better decisions and hold myself accountable because I know I have done a lot of wrong things. So I want you to know that before you sentence me.
You're saying that, and I was sending you to a program that would have exactly addressed what you just said, making better decisions and doing the right things, and you don't want to go. So I don't know how sincere or genuine you are.
Well, can I say something on
You
that?
can say whatever you want.
Okay, so when NeoCap came up here and explained that to me, they didn't explain me what their program was. All they explained to me was that I needed a lot of mental help. And I know that I do, but they didn't explain to me anything of what the program was when they came here. They just told me my life was all over the place and that I needed a lot of mental help. I feel like if I would have known what NeoCap was and how long the program was, I would have been fine with going. Realistically, I would have been fine. I didn't know what I was walking into. No, when they came up here, all they told me was I needed mental help in my life. I needed a lot of help. And I mean, you didn't explain to me anything of what your program was. So I was struggling, not knowing where I was going and what the program consists of. She just told me I needed a lot of mental help. I didn't understand what the program was or how long I'd be there or what the requirements was.
But you still don't want to go.
I do. I would like to go to NeoCap. I never told my probation officer I refused. I just had an emotional episode. And I flipped out because I wasn't on.
You
there
never
to
told him
show-
you want to refuse? I got basically a transcript of the conversation you had when you flipped out in the conference room. I could read it to you. Very first one, send me to fucking prison, bro. I ain't going to NeoCap.
I don't remember saying those words. I don't
You
remember
didn't even-
saying those words.
You're claiming you didn't even know you were sentenced to NeoCap.
Okay, because she had just told me I was, she played the sentencing video for me. Obviously, I had saw that I was sentenced after I had the misunderstanding. That was after the fact that she told me I had NeoCap. So I'm looking at it like I spent 4 months in jail, plus 60 days, plus 6 more months, plus 2 years papers. And I had completely lost it because I thought I was sentenced to 30 days plus JTP. So I had completely lost it.
You weren't even sentenced to JTP, was
Okay, it was a lot said when you were sentencing me. I had completely misunderstood what I was sentenced to. And the reason why I didn't ask or say anything about it is because my attorney told me he would come up here and meet with me and explain my sentencing. I've been calling him ever since. I just heard from him on Wednesday. And he told me I was going to prison. So, I mean, I just misunderstood my sentencing. I'm fine with going to NeoCap. I want to be on probation because I do think that it can help me get my life together.
Your Honor, and just very briefly, to my client's defense, I did in fact, after her sentencing, tell her that I would see her. And unfortunately, I did not get out to see her to explain her sentencing. So, not saying that's an excuse for anything that happened, but I did tell her that.
Probation was going over her sentencing with her. They were attempting to even just go over the rule. They still haven't been able to go over the rules with her because of how she acted with the probation department. They review the rules with them and make sure they understand the rules. They haven't been able to do that because of how she acted in that conference room that day. There wasn't an opportunity to explain it to her because she wouldn't give them that opportunity to explain it. When they were trying to explain it, I could read this for you if you want to know what you were saying to them.
That was after the fact that she told me I had NeoCap.
Yeah, right. And you didn't want to hear about it. You're complaining that nobody was explaining it to you. You didn't want to hear about it when they were trying to explain it to you.
She never even tried to explain it to me.
She didn't get a chance because send me to fucking prison, bro. I don't
was
care about any of your fucking
removed.
rules. You all just love to fuck people. Half a fucking year and you still won't get me an NF. You still won't let me go on an F5. Y'all fucking attorneys are horrible. I'm 20 years old, cuz. He didn't say NeoCap or I would have said no. He didn't say NeoCap or I would have said no.
Okay.
At least out of prison, no probation. Give me my time. I've been sitting here I can continue going on and on and on. And you're saying, and that's because she was trying to explain it to you, and she couldn't get a word in edgewise with you.
I was already removed when she told me about NeoCap. I had told her she had told me it was 4 to 6 months. That's all she told me. And
What do you mean you were already removed? This is when you were first.
No, I was in a different room when they came and got me. I was removed from her office. I wasn't even in her office.
Where were you going over the rules with her? In the conference room?
No, Your Honor, she was initially in my office.
Okay.
And we were going over rules. And then when we got to that rule, as soon as I brought up the NeoCap and she said she was not sentenced there, that's when I pulled up the journal entry, read the journal entry, and then replayed the sentencing for her. And we could not move any further into the conversation of the rules or anything else because of her behavior at that time.
I mean,
so that is.
I can continue going on and on about what you're. How was she supposed to explain it to you? There's no way she could have ever explained it to you when reading what you were saying.
Because she had already removed me from the room. She had already removed me before I even flipped out. She removed me.
She was escalating in my office. Then I did remove her from my office. We took her and that's when.
Took her where?
To the conference.
To the conference. You're still in the probation office.
And that's when
you went from her personal room to a conference room where there more people could be there for her safety, and she couldn't explain anything to you.
I feel like, I just feel like she didn't understand that I didn't understand what I was sentenced to. She tried to explain. She told me 4 to 6 more months. I had completely lost it, and You look at the words that I say, but I look at it like,
You're saying nobody was explaining it to you. She was trying to, and she couldn't.
the only thing she told me was it was 4 to 6 more months. That's when I lost it.
And then she couldn't say anything more after that because you lost it.
Neither did she try. I mean, she didn't even try to explain it to me. She didn't try to explain it to me.
You tell me how she's
Nobody
supposed to
would
try to explain it to
me.
you when you're yelling at her this shit.
She had already removed me.
She moved you from one room to a conference room. You're still in the probation department. She didn't bring you back to jail. You're in the probation office. She took you out of her personal office.
I'm sorry that I don't understand a lot of things. I'm sorry. I haven't really even been in a legal system before. This is my first time. I was sentenced to something I don't understand. And now you guys are about to hit me with whatever because I didn't understand what I was.
You're the one that says you want to go to prison. You said it over and over. Your probation officer came out here this morning. You're doing this against his advice. He wanted you to waive this hearing and let's see what happens. You didn't want to do that. You just want to get it over with. So I have no clue what you want to do. And it's clear that, well, you can say whatever you want to say.
I just feel like you gave me a chance with probation, but I didn't understand what I was sentenced to. Like, I don't know. I feel like anything I say in this case is going to be used against me. So whatever you sentence me to, Judge, you sentence me to. I just hope you take into consideration that I did things wrong, and I know I did things wrong, but I'm trying to fix it. And obviously, I see I'm building myself a deeper hole. But I mean, this is emotionally a lot for me. This is emotionally a lot for me. All of this is emotionally a lot. I realize what I did was a mistake, and I do have a lot of problems, but I honestly feel like I haven't even got out of jail to try to get the chance to fix them. Okay, Your Honor, so that's what I have to say in my case. Like, I know what I did was wrong. I haven't even got out of jail to try to fix them. And I understand that I'm facing a lot, but I'm trying to fix it, and I just keep on digging myself a worse hole. And I realize I'm the problem. I'm the problem, and I need help.
Do you want anything else?
Yeah, may I, Your Honor, just extremely briefly, and I believe I touched upon this at the original sentencing, and I had asked the court then that if given the chance of probation, if she's gets on medication, an opportunity to get back on her medication, and you know, maybe that would build a foundation for her to start getting better. We haven't even gotten to that point yet. To deference, Your Honor, I mean, she's explaining to the court she doesn't understand. I know the court was crystal clear with sentencing. I'm sure Ms. Crook was doing her best trying to explain everything, but clearly there's some mental blockage here with my client, and I'm begging the court to just, I know she said she wanted to proceed today.
Here's what we're going to do. I've accepted the plea. We're going to defer sentencing to a later day and come back for sentencing. Is there anything else at this time? You can have time to talk to her. I don't know what we'll do when we come back at sentencing, but at least you'll have a better understanding of what it's all about.
Nothing further, Your Honor.
All right.
Well, that was entertaining. I'm so glad we visited that court. First time. I think it needs to be first time, long time now. So Ashley just said something in the chat about she's not the center of the universe or her own world or whatever. Yes, she is, Ashley. You apparently didn't get the memo. Everybody is the center of their own universe now. So it completely tracks. Let's go to Miami-Dade. This is not Judge Glazer. This is Judge Camera's too blurry to clearly read her name. Let's see what's going on.
What is the bond on this?
So Judge, ¿cuál es la fianza aquí? A couple of things. Count 2, I don't know if the form gives the victim's age, but I think that there is probable cause on count number 1 for aggravated battery.
Su señoría, ante todo algunos puntos primero. En el cargo número 2, no sé si el informe de arresto ofrece la edad de la víctima, pero creo que tenemos motivo fundado en cuanto a la acusación número 1 para agresión física con agravantes.
So not for probable cause, but just for some context, I believe the victim's 17.
Entonces, no por razones de motivo fundado, pero más bien por contexto, creo que la víctima tenía 17 años.
She has no criminal history that I'm aware of.
I'm gonna require a bond in this case. In this case, the allegation is that she stabbed the daughter in the right thigh and then proceeded to bite her in the back. This is beyond. So what is the bond on count one?
Bond for
I'm sorry for the interpreter, I'm sorry, thank you. Entonces, indica la fiscalía, ella no tiene antecedentes penales, sin embargo, su señoría interjeta diciendo, yo voy a establecer fianza en este caso, ya que aquí las alegaciones son de que ella apuñaló a la hija en el muslo derecho y después procedió a morderle en la espalda, es simplemente demasiado. ¿Cuál es la fianza preestablecida?
7,500.
7,500.
Count one is 7,500 and in count two, although the age is not stated on the arrest form, the victim left the incident location, spent the night at a friend's house. DCF was contacted and DV ID was requested and it was issued. The victim was then transported to the station and then the defendant was arrested. So DCF
Y en cuanto a la acusación número 2, aunque no tenemos una especificación de la edad de la víctima, aquí se indica que la víctima salió del lugar del incidente y fue a quedarse a pernoctar esa noche a la casa de un amigo. Además, se contactó a las autoridades como por ejemplo el Departamento de Niños y Familia y además después la víctima fue transportada para atención médica.
So at this time, I am going to find probable cause on child abuse. DCF would not have gotten involved if she had not been underage. So what is the bond on that case?
2,500.
En estos momentos voy a determinar motivos fundados para abuso o maltrato de menores, ya que el Departamento de Niños y Familia no se hubiese involucrado si la víctima no hubiese sido menor de edad. ¿Cuál es la fianza preestablecida? 2,500.
You are to have no contact whatsoever with your daughter whose initials are JVO. You cannot have any drugs or any drugs or firearms.
Usted no puede tener absolutamente ningún contacto con su hija cuyas iniciales son JBO, no puede tener además ningún tipo de contacto con actividad delictiva, drogas, alcohol o armas de fuego o armas en general.
State, do you want me to do paragraph 7?
Yes.
Okay, and I am going to sign paragraph 7. The juvenile court will make a decision on future visitation and contact.
Y estoy firmando el párrafo número 7, indicando que el Tribunal de Juveniles tendrá la última palabra en cuanto a contacto con la menor y cómo van a ser las visitas con la menor.
You have the ability, if you bond out, to go to your house and go and take stuff out in 72 hours with the assistance of a police officer.
Muy bien, señor. Entonces, si usted puede pagar su fianza, se le va a autorizar regresar una sola vez a su casa en un plazo de 72 horas después de haber sido liberada, acompañada de un policía para que recoja sus pertenencias.
Anything else from the state?
No, Judge.
¿Con la fiscalía? No.
Your Honor, you're setting bond for the count 2 at 2,500?
Correct.
Se ratifica que la fianza para el cargo número 2 es 2,500.
Ms. Corey, anything else?
No, Judge.
Okay. Thank you.
Well, there between contestants, Michael, thank you for that gifted membership. Very much appreciated. You guys are always so supportive, and thank you so much.
Yes.
Okay. The next case is Chloe Castellanos.
This is an added charge. Judge Glazer has been setting standard bond with Nebula.
And what is the added charge?
The grand theft, organized scheme. financial institution scheme to defraud. So the state's requesting 2,500 each counts with Nebbia.
On Abreu, I'm sorry, it's Castellanos. These other cases recent or?
I don't know exactly when they're from, but she's got a lot of cases all involving the same scheme.
What is the state's request on this defendant?
Standard with Nebbia, which is 2,500 each counts.
On each of the counts?
Yes.
Could you do 1,000 each count?
Okay, I'm trying to figure out, does she have other bonds on other counts in another case, or is it the same this same case, or what?
There's multiple cases, Judge. 4, 5, 6.
I think a half dozen.
9.
9 cases?
Yes.
So is she out on bond on them, or is
No,
she?
Judge, she hasn't been out. She hasn't been able to get out yet.
Okay, so all of these okay. And she, other than these cases, I'm not minimizing them, but there have been no prior significant cases, am I correct?
Yes.
Okay, it will be $1,000 on each of the counts. So it's $1,000 and the total is 4,000.
I think there's 5 counts now.
Yes.
There are 5 counts? Thank you, okay. The identification, what is the bond on that? The usual bond?
The standard bond on the count on each count is usually
Is one?
Standard bond is 2,500 on all counts.
Okay, so count 5 is also 1,000 on this case.
And the state's request for Nebbia?
Does she have a Nebbia on the other cases?
Yes.
Okay, Nebbia on this case. Together with whatever the other cases are. Okay. Lovanta Patterson.
Your Honor, he was on house arrest and was rearrested on this case.
And he was rearrested for.
So Judge, corrections. It looks like the F-24 case is printing off calendar. That should be off calendar, correct?
Yes, the F-24 26477 was the case that he was on house arrest, and now he's rearrested on this new case, F-25 20464.
So the state's requesting that Your Honor set the bond on 6-4 and hold the defendant on the F-24 case to see his judge on Monday.
What is the felony hold? F-24-1?
20464. I'm sorry, it's F-24 26477.
26477. So
Yes,
on
that's
this
the
case,
hold.
What is the standard bond on count 1?
So the only case before the court is F-25 20464. Standard bond is 5,000 on count 1, 500 on count 2.
Okay, I find probable cause for resisting arrest or, I'm sorry, battery on a police officer, and that is a $5,000 bond. Count 2 is resisting, I'm sorry, what is the standard on that?
500.
500. And there's a felony hold on F-24 26477. Tomás Borges. Okay, can we get a chair for this defendant, please? Public defenders appointed.
The Spanish interpreter, please.
Okay, maybe
Perfect.
there's a chair right behind them. Corrections, can we get that chair over?
They're
So,
bringing a chair, Judge.
okay, take your time. Ms. Corey, can you find out, did this injury on his left leg happen with, or he had it already? Can you give me any?
Muy bien, su señoría quiere descifrar si esta lesión en su rodilla ocurrió antes de entrar acá o estando acá o tener una idea.
It's a new injury, Judge.
Es una lesión nueva.
He has a history going back to the 90s.
Aquí tenemos un historial que retrocede hasta los 90.
He also did 15 years in state prison in Broward County for a robbery.
Él también cumplió 15 años de prisión estatal en el condado de Broward por hurto.
And when was he released from that?
¿Cuándo fue liberado?
It looks like his most recent release from prison, July 1st of 24.
Al parecer aquí se indica que su liberación más reciente de prisión fue el 1 de julio del 2024.
What is the standard bond on robbery?
¿Cuál es la fianza preestablecida en hurto?
$7,500.
Count 1 is straight bond 7,500 and count 2 500. And corrections, please follow up if he needs further medical care. Sir, you are to have no contact with the victim in this case, Sofia Jimenez. No contact means you cannot contact her directly or through anybody else. You understand the extent of the no contact order?
Muy bien, entonces en el cargo número 1 imponemos fianza de $7,500. En el cargo número 2 impongo fianza de $500. Por favor, penitenciarios, encárguense de asegurarse de que él reciba los servicios de cuidados médicos que necesite en caso de necesitar. Señor, se le informa de que usted no puede tener ningún tipo de contacto con la señora Sofía Jiménez. No tener contacto significa que no le puede contactar de forma ni directa, ni indirecta, ni a través de otras personas. ¿Usted comprende el alcance de esta orden que le estoy dando de no contacto?
Yes.
Yes, ma'am.
Okay. Okay, thank you. And
Gracias.
take your time getting back, and the next case will be Jonathan Eugene.
Okay, we'll come back to Miami-Dade perhaps in a little bit. Let's change it up. We'll go to Wisconsin, see what's going on with Judge Mogan.
Court. We have his counsel, Michelle Erdman, appearing by video conference. We're set today for a plea and sentencing hearing. Before we begin, Mr. Ankeny, you are appearing by telephone and your attorney is appearing by Zoom, by a video. And you have requested to appear this way, is that correct?
Yes, ma'am.
And do you understand that you have the right to be here in person if you wish?
Yes, ma'am. Logistically, it's not feasible.
And I understand that. I just have to ask this, I have to put it on the record for appeals purposes, that kind of thing, okay? So do you understand that if you have any questions or you have any concerns, I will send you both into a confidential breakout room so you can discuss anything that you wish with your attorney, okay?
Okay.
All right, Ms. Erdman, the parties have reached an agreement. Can you please recite the agreement for the record?
Judge, we've filed a plea questionnaire some time ago. It was document number 46. Mr. Ankeny is going to be pleading to 3 misdemeanor level charges today. Misdemeanor possession of amphetamine, possession of a controlled substance, and then possession of THC. And Your Honor, the parties have agreed that he would be on 2 years of probation, and the standard terms of conditions of probation, including AODA and follow through and complete any programming that he's enrolled. I think that's kind of expired since the prior agreement was entered, but we would expect if he is ordered to do any, or if his probation agent feels anything would be useful, that he would follow through with that treatment as well, Your Honor.
All right, thank you. And Mr. Ankeny, you live in Richfield, Minnesota, is that correct?
Yes, ma'am.
And that's on West 72nd Avenue?
Yes, I believe it's either Avenue or Street.
Okay, thank you. All right, and so he'd be pleading to 3 misdemeanors and we're asking him to stay on Burnett County probation?
Yes.
Okay. And so, Mr. Ankeny, do you understand, and before I get into taking your plea, I just want to make sure that you understand that if the court does follow the recommendation and does place you on a period of probation, that it would need to be through Burnett County office. It cannot be transferred, most likely, because of the interstate. Now, the interstate compact, they have agreed, or they do not wish to accept misdemeanor pleas for their probationary review and oversight. So do you understand that you would sometimes maybe need to come in person to Burnett County to your probation agent?
I did not understand that. I'm hearing it now, and that sounds kind of difficult. It took me 2 years to get up this last time.
Okay, so I can't guarantee that they won't transfer it. I can't guarantee that they will transfer it, but there is a possibility that you may at sometimes need to come in person for some random drug screening. You may not. I'm not the Department of Corrections. They may have you just do Zoom appearances. I'm not sure. I just want to make sure that you understand the ramifications of having a probationary recommendation.
I'm beginning to. Thank you.
All right. So at this time, would you like to have a little breakout session with your attorney, or do you feel comfortable enough to proceed with the plea and sentencing?
I don't want to waste anybody's time here. Let's roll.
Let's roll. Okay. All right. So I do have in front of me a plea questionnaire waiver of rights form, and you did sign it some time ago on October 3rd, and it's 2023 because you were ready to plea and you were ready to be sentenced. But then for some reason you didn't appear and the court issued a warrant, and it was some time before you were either, I believe you were picked up on the warrant. Is that correct?
No, it's not. Well, it may have been at one point, but he turned himself in. He wanted to get this matter addressed. So he came there. His dad gave him a ride back last month.
All right. So that's good to know. All right. So
Earlier
Mr.
this month.
Ankeny, this was signed on October 3rd, 2023. And Ms. Erdman, you're indicating that he understands everything. You went over everything on this plea questionnaire and everything is still accurate and true, other than those other conditions such as the AODA and fall through, because he's been through treatment, correct?
That, and I suspect he's probably gotten a little older, but other than that, I think everything should be accurate, Judge.
Yes, I'm going to guess he has, since it is now 2025. Okay, Mr. Ankeny, how old are you?
91. I'm 34, I believe.
You're 34. All right, so you're 34. And do you remember accurately what is in this plea questionnaire, and do you understand it?
Yes, it's basically dropping 2 felony counts down to misdemeanors and agreeing to go on probation.
Right, and it had a whole lot of other things on this, such as your constitutional rights and what you'd be giving up, and some other things. So your attorney went over this with you, is that correct?
Yes, ma'am.
And so you understand everything on this document?
Well, I don't think I'm that smart, but I get the gist.
Well, I need to make sure you are that smart, that you understand everything. And I'm going to go over quite a bit that's on this plea questionnaire. But when your attorney went over this with you, did you at that time understand what she was explaining to you?
Yes, ma'am.
Okay. And so I'm going to refresh your recollection. I'm going to refresh your memory and go over some of these things with you again, but not in exact detail. Okay.
Okay, thank you very much.
So you're pleading guilty to 3 misdemeanor counts. First, I have to ask the state formal motion to amend count 1 to possession of amphetamine.
So made.
Granted. So you're pleading guilty to possession of amphetamine, possession of a controlled substance, and possession of THC. Is that all correct?
Yes, ma'am.
You're 32 years old. You're 34 years old. You have 16 years of schooling. You can read, write, understand the English language. You have not had any drugs, alcohol, or other medications in the last 24 hours. Is that correct?
No, ma'am.
And you are currently receiving treatment for a mental illness or disorder. And would that be your substance abuse disorder?
Yes, and depression.
And depression. And so with your depression, are you in a place right now where you can fully understand and comprehend what's going on?
I am cognizant, coherent, and capable.
I'm very glad to hear that. Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that document. I will briefly go over those rights with you to make sure that you understand what you're giving up. You will no longer have the right to a trial. You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify or to remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, ma'am.
You understand that if you're not a citizen of the United States, your plea could result in your deportation.
Oof, crazy times we live in, but yes.
Yes, but legally, and I'm told I must ask that question to everybody just in case, so you understand that you could be deported. And so it gives you an opportunity to think a little bit more carefully about your decision. So do you also understand that here, the state would have to prove as to the amended count 1, possession of amphetamine, that you possessed a substance, the substance was a controlled substance in an amphetamine classification, and that you knew or believed that substance was a controlled substance in an amphetamine classification. Do you understand what the state would need to prove?
Yes.
And do you understand the maximum possible penalty could be a fine of up to $5,000 or 1 year of incarceration or both?
I understand. Yes.
You understand as to count 3, possession of a controlled substance, the state would have to prove that you knowingly possessed diazepam, a controlled substance without a valid prescription. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $500 or imprisonment of up to 30 days or both? Do you understand that?
Yes, ma'am.
As to possession of THC, do you understand the state would have to prove on or around April 10th, 2022, that you knowingly possessed a controlled substance, THC? Do you understand, and do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or imprisonment of up to 6 months or both? You understand that?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea here today?
I do.
Do you have any questions for the court or for your attorney before I proceed?
I do not believe so.
You understand that there is a recommendation for the court to place you on probation with certain conditions. Do you understand I'm not bound by that recommendation?
I did not know that.
All right, well, I'm telling you now, do you understand that? That means that I could sentence you to anything that I feel would be appropriate in the circumstances, which could be a fine, it could be probation, or if I thought it was warranted, an aggravated case, I could sentence you to the maximum possible penalty for these crimes. Do you understand that? Is that a yes?
Yes, ma'am.
All right. Do you still wish to proceed and enter guilty, please?
Yes, ma'am.
Did your attorney go over the criminal complaint with you? And there's a section called the probable cause section where it basically says what happened and why you were charged with the crimes?
If we did go over that, it's been a while.
And so do you recall that day and what happened? And so are you admitting here today you in fact did possess a substance in an amphetamine classification?
Yes, I guess, yes.
Is that a yes? Or did you?
Yes, ma'am.
All right. And so you knew it was an illegal substance?
I did.
Did you in
Wasn't thinking
fact?
about it much at the time, but yes.
I appreciate that statement. Did you also have in your possession a controlled substance and you did not have a valid prescription for that?
Yes, ma'am.
And you knew you could not possess that without a valid prescription?
Yes, ma'am.
Did you in fact possess THC marijuana?
Yes, I do.
And you knew that that was an illegal substance in Wisconsin?
Yeah, I guess, yes.
Yes, it's illegal in Wisconsin.
thought you
live
guys
in
had
Minnesota,
legalized
do what you
it.
want there. What?
Okay. I
All
thought
right,
you guys
so
had legalized it by now, but
Oh, nope.
been a while.
Probably not going to happen.
Hmm.
It's probably
Well.
not going to happen. So if anyone believes that they can come here with THC, they cannot. So just kind of drive around, go on the bottom side of Wisconsin or the top side of Wisconsin. You're free to go. Just can't drive in Wisconsin or be in Wisconsin and have THC, okay?
Good to know.
All right. So has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, ma'am.
and voluntarily.
Yes, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Do you have any questions for the court or your attorney before I proceed?
No, I have none.
As to count one, possession of amphetamine, how do you wish to plead?
Guilty.
As to count three, possession of a controlled substance, how do you wish to plead?
Guilty. Oh,
As
I'm
to-
sorry. I think I pressed a button. My bad.
That's okay. So what was your plea?
Guilty, ma'am.
As to count four, possession of THC, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt based upon your admissions. The court will dismiss and read in count 2 and count 5. The judgment of conviction will be entered today. Argument and recommendation, Mr. Schmidt.
I think the probation is necessary in this case. I think Mr. Ankeny needs a little bit more help controlling his substance abuse issues. In this case, there are kind of two things that kind of concern me above the norm. One was him being with Patrick Stewart when he had heroin paraphernalia, showing him in the presence of someone with a much more dangerous drug. And two, the presence on him of that modified flare gun that was set up to fire rock salt instead of a flare. That demonstrates that wherever Mr. Ankeny's substance abuse was going back then,
it was taking places at least he perceived as being dangerous to himself. So to the extent I want to make sure he doesn't get himself in a position where he's in danger, I think getting a hold of that is important. Thank you.
Thank you. Ms. Erdman?
Judge, Mr. Ankeny has been someone who's gotten a hold of me repeatedly over the years, just trying to get this figured out and resolved. He's the one that proactively reached out to me and said, hey, I think I can finally figure out a ride. I've got my dad lined up. He came in, gave his DNA, got everything set up that way, made the appearance. He's been pretty diligent about trying to get this resolved, even though the challenges with transportation have been long. I do think that when I speak with him today, I hear a clear-headed young man that seems to be doing the right things. He's committed to, I think, staying out of trouble, addressing his issues, and he's definitely on the right path. So for those reasons, Your Honor, we just ask you to consider the recommendation.
All right, Mr. Ankeny, is there anything you want to tell me, anything you want to say, anything you want to let me know?
Yes, actually, I'd like to make a statement to the court.
I would love for you to make a statement, and I'm going to tell you, I would like to hear a few things too in that statement. Like if you're on probation in Minnesota, any kinds of treatments that you had, your sobriety date, those types of things, okay?
Yeah, I was actually going to address all of that.
I am so happy to hear that. You go ahead.
I keep pushing buttons. I apologize. Let me start with this. I have chronic pain and health problems. I've had 5 major hip surgeries. I've been dealing with an opiate addiction for the entirety of my adult life. So you, Mr. Schmidt, you were concerned that my addiction was going down a dark path. I am excited and happy to inform you that I am on a better path now. I'm in a much more stable living environment, and my addiction is much more under control. It is not entirely managed, but I'm trying very hard to make it so. Let's see, I am not on probation in Minnesota. I have no other legal quandaries or quarrels with any law enforcement in this nation, and I have no priors. So I really am trying my best to improve my life, become a productive member of society.
These are your first convictions?
Yes, ma'am.
All right, thank you. And tell me what you're doing with treatment and what you've done with treatment.
I'm not currently in treatment. I'm pursuing sobriety of my own volition and free will.
But you were in some type of intensive outpatient treatment, correct? Back in 2023?
I was. Have you heard of Evergreen?
I believe I've heard of it. I don't know much about it.
Rampant corruption, 40 million in fraud in under a year.
Oh, wow.
Yeah, that's where I was.
All right.
It wasn't great.
Okay.
Frankly, having absolutely no treatment is better than being at Evergreen.
Well, that's sad to hear. Do you go to any meetings? Do you go to, or do you have a sponsor, anything like that?
No, frankly, I've found socializing with sponsors and other addicts has led to more addiction.
Okay. Why were you in Burnett?
I was visiting a friend and Patrick Stewart, first time I ever met him, and the last, hopefully.
I'm glad to hear that too. Now, Mr.
Yeah.
Ankeny, do you have any need to come into Burnett at any time?
Unless it's to give urine, no.
All right. So let's just say you're off of probation, all of those things. You have absolutely no need to come into Burnett County for any reason. And if you still have a friend, your friend can visit you in Minnesota?
Absolutely.
All right. Anything else you want me to know?
I hope you've been well and have a good day.
Well, thank you. All right. So this is I don't want to say this is a tough case with it's complex or anything of that nature. This is not a complex case. This is a case where we have an individual who has a substance abuse disorder, an admission to a substance abuse disorder. He's had some self-reflection. He understands his addiction, and he's been working very diligently to try and take control over his addiction. It sounds like he's in a much better place than April 2022, and he's with much better people than he was in 2022. This is your first conviction of any criminal activity or criminal charge. So there was not any bond violations in this case. The only thing is that when we had the matter set for a plea and sentencing, I believe way back, it was 2023. I believe it was supposed to, yes, it was supposed to take place on November 15th, 2023, and you failed to appear, and then a warrant was outstanding until just recently. But I do recall now you did come in and you turned yourself in for the warrant, and then you bailed yourself out, and you had your other court date, etc. That may have gotten a little confused because you didn't appear there, but then the court did quash it to allow you to get this matter resolved. It sounds like you're doing pretty well. It sounds like you've been trying very hard to stay away from the people that drag you down and bring you down the wrong path. And so that's something that's positive. Do you live with your father?
I'm afraid not, ma'am.
Afraid not? Where do you live?
I live in Minnesota. He lives in New Mexico.
Oh, I'm sorry to hear that. But it's good to hear that he was up here and helping you when he did. Do you live by yourself?
Yeah, I
or
got
do you
lucky.
have Okay. And so you're working very hard on your sobriety, and I'm very glad to hear that. Knowing all of these things, I have not seen that you are a risk to the community, especially around here. You have no reason to be in Burnett County. You met Patrick Stewart one time. You have no intention on being around Patrick Stewart again. That is very good to hear. You need to stay with people that can help you with your sobriety, help you maintain your sobriety, not bring you down the other road. So I'm very glad to hear that. In knowing all of these things and looking at this with the totality of all of the circumstances, all of the things that I have to look at here, I'm not following the recommendation. I'm not going to place you on probation. I'm not going to set you up to fail, because if you need to travel to Burnett County and you aren't able to travel to Burnett County to do drug tests, etc., then you're going to get a warrant and you're going to need to have probation holds, etc., because it would look like you're absconding. It sounds like to me, since 2022, you have done things to get yourself in a much better place, and I'm glad to hear that. I do not want to see putting you into the system and having that actually do something negative. I'm going to believe you that you're continuing to do what you need to do. You're staying away from people that you should not be around. I'm going to trust that you're going to continue to do that. So I'm not going to place you on probation. I'm simply going to assess $250 per count. You have 700, did I do that right? Yeah, you have $750 posted. So that means you are good to go. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need to order your DNA. You've already provided it. Thank you. You have the ability to request that be expunged from the system through a written letter to the Department of Justice, not to the court, not to me, to the Department of Justice. I believe you have jail days. I don't know how much. How long do you think you spent in jail?
I believe 2 weeks.
2 weeks, and that's in the totality of this case from when it started?
I've got 18 days,
Yes, ma'am.
Judge.
All
Like
right,
from the
so what
very
I'm gonna
beginning.
do is I'm also sentencing you to 20 days of jail, time served, 18 days of jail credit.
Oh, cool.
All right, so I believe, again, 20 days to appeal. I think I've covered everything, Mr. Schmidt.
Nothing for me.
Ms. Erdman?
Judge, I think he can set up a payment plan with your clerk of court if he can't pay.
Oh, I
I'm
don't need
sorry,
money.
He's got the money on file. He's got money on
Yep.
file, so we're good. That's all. That's
We're
all.
good. All right. Thank you.
Okay.
We are adjourned.
Oh, thank you so much, Judge. Very unexpected and very, very appreciated. Thank you so much.
Mr.
I don't
Go ahead.
mean to be rude, but I hope this is the last of our interactions.
I hope so too. Mr. Ankeny, I sentenced you how I feel it is appropriate and sentenced you based upon what I've seen, well, what I've heard. I haven't seen you, but what I've heard you've been doing. I want you to continue down that path, and I don't want to create any obstacles for that. Do what you need to do. Stay in control of yourself. Take control of your sobriety and your substance abuse disorder. You're doing great. Keep it up.
Thank you so much.
All right. Thank you. We are adjourned, or we were adjourned. You don't have to have that.
I gotta say, I don't think I've ever seen a situation where a defendant reacts with the words, "Oh, cool," when sentencing is done. That was a weird interaction, and the only thing I gained from it, now admittedly I was multitasking, so I missed parts of it, but the only thing that I gained from it was that apparently it's not a good thing for you to meet Patrick Stewart. So, who knew? Let's go back to Lake County, Ohio. Judge Collada has another hearing going. Let's see if this one's as interesting as the first.
0887. Defendant is present open court today with his counsel, James Matthews. Your Honor, we're here on a 3-count information that was...
And because I forgot, thank you, Grandma TCF, for 17 gifted memberships, and thank you, Ashley, for 5. Mom, I see what you did there. 17 gifted memberships for our 17th anniversary for me and Mrs. TCF. We appreciate it. Back to Judge.
Operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, an unclassified misdemeanor. It's the state's understanding today that the defendant will waive his right to indictment, and then he will plead to the 3 counts and the forfeiture specifications in the information. At that time, we would ask to defer sentencing so that a pre-sentence report and drug and alcohol evaluation may be completed. There's no sentencing agreement, and that is the state's understanding at this time. Thank you.
The OVI is what? In how many? I know it's a misdemeanor, but
He has 2 priors, so...
in the last 10 years?
The third. Yes,
So this is the third
correct. He has 2 prior convictions.
in the past 10 years.
Correct.
That's why it's unclassified, right?
Yes.
The discretionary license is actually mandatory license if you have a possession when you're in
correct.
connection with an OVI.
You are correct, Your Honor. I apologize.
And you may have said it, but is there any agreement as to sentencing here?
There's no sentencing agreement.
Mr. Matthews, does that all sound accurate?
Yes, Your Honor.
Mr. Frank, were you able to hear what the prosecutor had to say regarding what she believes your plans are here this morning?
Yes, Your Honor.
She indicated to the court she believes it's your desire to waive your right to have this case presented to a grand jury, and I'll explain in a moment what that means in more detail, and to go ahead and plead guilty to the charges in this information, which I will also review with you to make sure you understand them. We would then defer sentencing to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. When I'm asking you these questions, if you're unclear about anything, need me to repeat anything, if you want a moment to talk with your lawyer to ask him questions, or if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
All right.
All right. Let's get started then. How old are you, sir?
33.
Are you able to read and write the English language?
Yes, sir.
Any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes.
Now, prior to coming in the court here today, have you any drugs or alcohol of any kind?
I just took my methadone this morning.
Okay. So you take methadone daily?
Yeah.
Okay. Anything else?
I will also be dirty for marijuana.
When did you last have marijuana?
Like 3 days ago.
Supposed to do marijuana with methadone?
What's that?
You're supposed to do marijuana with methadone?
They're not against it. They,
So when's the last time you did marijuana?
like 3 days ago.
Anything else?
No, Your Honor.
What about prescribed medications?
Nope. Just the methadone.
Right. Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charges you're accused of committing and what you're going to be pleading guilty?
That's the one we went through. Yeah. Yes, Your Honor.
You had a chance to look that over?
Yeah.
In that information, you're charged with 3 counts. Excuse me. Count 1, what's alleged here and what you're admitting to is on or about June 8th, 2025 in McNally County, Ohio, that you did knowingly obtain, possess, or use bromazolum or some compound mixture, preparation, or substance containing bromazolum, Schedule 1 controlled substance. The amount did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs a felony. The amount did equal or exceed the bulk amount, and that's what makes the offense aggravated possession of drugs a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes, Your Honor.
Any questions about it?
No.
Charge also carries a forfeiture specification that alleges you possess or had an interest in property considered to be contraband or an instrumentality. Contraband is property that is illegal just by the nature of the property, like drugs. Instrumentality is some type of property that there may not be anything illegal about it in and of itself, but it's being used in an illegal manner to facilitate a crime. You can't use or possess it for that purpose. Here it's alleged there's some pills and tablets, some LSD, ketamine, paper, square, containers, vape cartridges, gummies, marijuana, and packaging. Whole point of this specification is that you forfeit any ownership interest you have in any of that property at the time of sentencing. You understand that?
Yes, sir.
Any questions about it?
No, sir.
Now, count 2, what's alleged is on or about June 8th, 2025 in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine. That's a Schedule 2 controlled substance. The amount of the methamphetamine did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, Your Honor.
Any questions about that?
No, sir.
This charge also carries with it a forfeiture specification involving methamphetamine and packaging. You understand that?
Yes, Your Honor.
Lastly, in count 3, what's alleged here is on or about June 8th, 2025 in Mentor Lake County, Ohio, that you did operate a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's further alleged that within the past 10 years, you have previously been convicted or pled guilty to 2 other violations of operating a vehicle under the influence of alcohol, one being in the Portage County Municipal Court on January 23rd, 2023, the other being in the Cuyahoga County Common Police Court on June 28th, 2023. So that conduct with those priors makes the offense operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, and it's an unclassified misdemeanor. You understand what you're charged with and pleading guilty to in count 3?
Yes, sure.
Any questions about that?
No, sir.
Well, then before I can accept your guilty plea to these 3 charges, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have the right to have this case presented to a grand jury. Now, the charge I just read to you is called an information, and an information is a criminal charges that are brought by the prosecutor's office without the case having previously been reviewed by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. And you have that right as well.
Yes, sure.
But you can give up that right if you want and go forward on the charges brought by the prosecutor and the information. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, sure.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing. And I have in my possession here a document, a one-page document called a waiver of indictment, which sets forth what I've just explained to you about this grand jury process. And that one, you want to give up that right. Before I can go any further, I need to make sure you understand what this document says and that you sign it here in court. Now, my understanding is before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, sure.
Mr. Matthews, is that accurate? Did you read this over with Mr. Frank, review it with him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Frank?
Yes, sure.
Any questions for me about what it says?
No, sir.
Now, it also appears, Mr. Frank, that you signed this document. Did you sign it?
Yes, Your Honor.
Can you witness that, Mr. Matthews?
Yes, Your Honor.
You too, Ms. Cutts?
Yes, Your Honor.
Very well, I'll make the document part of the record for this case. At this point, Mr. Frank, I'm going to review with you all the other rights you're giving up by pleading guilty, and you first of all have a right to have a trial. And a trial can be me as a judge, or I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence presented. Those jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you were guilty or not guilty of each separate charge. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a jury trial and have any trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would represent the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, that burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof we have in our justice system. What it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges at a trial. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt of each of the elements of these charges?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, the prosecutor will bring witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that is called cross-examination. He can ask him anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that, but you have a right to do that if you want. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. You understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's solely your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if we did go to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding that I will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
You still want to plead guilty?
Yes, sir.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to 3 charges. Count 1 is a felony of the 3rd degree, which is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, 30. You understand that?
Yes, Your Honor.
So I'll select one of those numbers, and that'll be the number of months in prison you'd have to serve. You understand that?
Yes, Your Honor.
Now, count 2 is a felony of the 5th degree, which is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, Your Honor.
Now, count 3 is an OVI. It's an unclassified misdemeanor. In this particular OVI, it's punishable. It can't send you to prison, but I can send you to order that you serve time in the local jail, the Lake County Jail. You have to serve at least 30 consecutive days, and I could sentence you up to a full year of local incarceration. You understand that?
Yes, Your Honor.
Okay. Now, in regards to the felonies, I explained that they are subjected to prison terms. If I impose a prison sentence on those counts, I'd impose it on each count, count 1 and count 2, and then as the judge, I have the discretion to run those prison terms concurrent or consecutive to each other. Concurrent means you serve them at the same time together. Consecutive means one after the other. You'll serve the prison term on the first count, whatever it is, complete it, then serve the prison term on the next count. So you understand the difference there?
Yes, sir.
Now, in regards to the misdemeanor OVI, if I do send you to prison on the felony charges, any jail sentence ordered for the OVI has to be served concurrent. I can't run that consecutive. So the maximum prison sentence you face in this case is 48 months or 4 years in prison. You understand that?
Yes, Your Honor.
Now, you're currently on probation or parole to any other courts or agencies?
No, sir.
Do you have any other charges pending against you anywhere?
No, sir.
If a prison sentence is imposed on counts 1 and 2 upon your release from prison, you could be placed on what is called post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you served the prison sentence. And in this particular case, it could be for up to 2 years. Do you understand that?
Yes, Your Honor.
If you're in post-release control and you're violating the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 15% or 50%, 50% or half of the prison term imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. Count 1, the felony 3 drug charge carries with it a mandatory fine of at least $5,000 that must be imposed, and it could fine up to $10,000. Do you understand that?
Yes, Your Honor.
Count 2 carries with it a possible fine of up to $2,500. You understand that?
Yes, Your Honor.
In count 3, the OVI carries with it a mandatory fine of at least $1,040 up to possibly $2,750. Do you understand that?
Yes, Your Honor.
So in this case, a minimum mandatory fine of $6,040 will be imposed. You could be fined up to $15,250. You understand that?
Yes, Your Honor.
Now, in regards to those mandatory fines, if you are indigent, your lawyer can file what's called an affidavit of indigency only on the drug charges. That's the $5,000 mandatory fine. And if I find based on an affidavit, if it's filed, that you're indigent, I can waive the $5,000 mandatory fine, but I'm not allowed to do that for the $1,040 minimum mandatory fine for the OVI. That's got to be imposed no matter what. Do you understand that?
Yes, Your Honor.
All right. I could also order that you pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
There's also mandatory license suspension that's required for all 3 of these counts. On the 2 drug charges, is a mandatory suspension of up to 5 years. So it could be 1 day, it could be up to 5 years. But that's mandatory. The paperwork said discretionary, but I need to make sure you understand. Since it was committed in connection with an OVI, it becomes mandatory. It's not 5 years, it's up to 5 years, up to 5 years. Now in the OVI, there's a mandatory license suspension of at least 2 years and up to possibly 12 years. Do you understand that?
Yes, sir.
The OVI charge in count 3 also carries with it a mandatory forfeiture of the motor vehicle that was being operated at the time of the offense if it was registered in your name. Do you understand that?
Yes, Your Honor.
Also, in regards to those forfeiture specifications that were mentioned, any right, title, or interest you have in any of that property will be forfeited to the state of Ohio. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence you face for counts 1 and 2. I used the word possible because prison is not mandatory. You are eligible for probation, or what is referred to as community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that, if that's what you're asking for. I'm going to look at all the information that gets presented, then I'm going to make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, while you are eligible for community control sanctions, in count 1, there's a presumption for prison, which means there's a presumption that the court must impose a prison sentence unless certain findings can be made that would allow the court to overcome that presumption, rebut that presumption, and place you on community control sanctions. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control sanctions, it could be for up to 5 years, and as judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions can be in order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation on the felony charges. Do you understand that?
Yes, Your Honor.
Further, if you are on community control sanctions and you're violating the conditions, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you. Or I could terminate your probation and send you to prison at that time. And if I did that again, it could be 36 months on count 1, another 12 months on count 2, consecutive for 4 years in prison. Do you understand that?
Yes, Your Honor.
That would also be, or could also be consecutive to any other prison sentence you may be serving at that time for some other case, or that you're being sentenced to at that time for some other case. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want me to know or consider. Your lawyer has the right to speak on your behalf. He can recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to talk about this case with your lawyer, have him review everything with you and answer all your questions?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has anyone made any promises to you, your lawyer or anyone else for that matter, regarding what's going to happen at sentencing?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering your guilty plea freely and voluntarily?
Yes, sir.
All right, then. Do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to talk with your lawyer before we go forward with your actual plea of guilty?
No, sir.
All right, then what's going to happen at this point, the prosecutor is going to explain for me what she believes the evidence would show if we had a trial. I need you to listen to her because then I've got some questions for you, all right? Ms. Cutts?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on June 8th of 2025, shortly before 8 p.m., Mentor Police Department was dispatched to the Starbucks located on Reynolds Road in Mentor Lake County, Ohio, for concern of a customer being under the influence. A work had indicated that there was a white male wearing a black jacket, black backpack, having driven a motorcycle to the store, who was slurring his words and his eyes looked unusual. When the officers arrived, the defendant, Jason Frank, was pointed out to them. When the officer approached, the defendant's speech was slow and slurred. His eyelids were twitching. He was sweating a large amount. He agreed that he had driven the motorcycle to that location. Officers asked about taking any medications or drugs. He indicated he did not take any medications and he had not taken any drugs that day. The officers had the defendant step outside and at that time conducted standardized field sobriety tests, the HGN, the walk and turn, the one-leg stand. There were issues with completing all of those tests, including issues with balance and keeping his eyes open. The defendant was placed under arrest for OVI. He was found to have 2 prior OVI convictions, both in 2023. When the officers were going through the defendant's items, including a backpack and a bag, as well as his coat and his clothing, they found a brown vial as well as other items on him. The brown vial that was later sent to Lake County Crime Lab was found to contain methamphetamine, a Schedule II controlled substance. In the other items he had, there was a THC vape cartridge. In the backpack, there was a prescription bottle that was filled with pills more than what was supposed to be in the pill bottle. There was in the front pocket gummies, a bag of suspected marijuana, a bag of a crystal substance, broken pill, and a dose of what appeared to be LSD. The defendant indicated that he had purchased the crystal substance that was methamphetamine in manner. Defendant was transported to Tri-Point. A search warrant was obtained to draw his blood. The items were all sent to the Lake County Crime Lab. The crystal powder was found to be 2.12 grams of methamphetamine, a Schedule II controlled substance. There were 56.25 pills or unit doses of bromazolam, Schedule I controlled substance, and there were other drugs such as triazolam, LSD, and ketamine found on some of the items. The blood was presumptively tested at the Lake County Crime Lab, and then the Miami Valley Regional Crime Laboratory did confirmatory testing and found, among other things, methamphetamine and bromazolam in the defendant's blood. All of this occurring in Lake County, Ohio, and that would have been the state's evidence.
Thank you. So, Mr. Frank, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then regarding count 1, charging with aggravated possession of drugs, felony of the 3rd degree with the forfeiture specification, what is your plea to that?
Guilty.
Regarding count 2, charging with aggravated possession of drugs, a felony of the 5th degree with the forfeiture specification, what is your plea to that?
Guilty.
And lastly, regarding count 3, charging with operating a vehicle under the influence of alcohol, a drug abuse, or a combination of them, an unclassified misdemeanor, what is your plea to that?
Guilty.
All right, I have in my possession here another document. This is a 5-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand what this document says, that you sign it here in open court. Now, my understanding is, before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Matthews, is that correct? Did you review this with Mr. Frank, read it to him, explain it?
Yes, Your Honor.
Did he indicate an understanding of it to you?
He did.
Is that correct, Mr. Frank?
Yes, Your Honor.
You have any questions for me about what it says?
No, sir.
Now, it also appears that you signed this other document. Did you sign it?
Yes, sir.
And Mr. Matthews, you witnessed that?
Yes, Your Honor.
And you as well, Ms. Cutts?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, aggravated possession of drugs, a felony of the 3rd degree in violation of 292511 of the revised code with the forfeiture specification. Count 2, aggravated possession of drugs, a felony of the 5th degree in violation of 292511 with the forfeiture specification. And lastly, count 3, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, an unclassified misdemeanor in violation of revised code section 4511-19A1A. I will defer sentencing, order a pre-sentence report investigation, drug and alcohol evaluation, set bond and own recognizance. Were there any conditions aside from no drugs or alcohol?
There was, I believe, a no driving as well.
All right, so no drugs or alcohol, no driving. What all this means, Mr. Frank, basically your bond, I didn't really change it. It's an owner cognizance bond, which means you have to show up at all future court dates. If you fail to appear at any future court dates, that's a separate felony that you can be prosecuted for, in addition to whatever happens in these cases. You understand that?
Yes,
So it's obviously important you show up. When's the next sentencing? When's the sentencing date stand?
10/27 at
2 p.m.
2 o'clock.
So your next court date's October 27th at 2 o'clock. You understand that?
Yes, sir.
Now, one of the conditions of your bond is that you don't use any drugs. It's been a condition of your bond. Why are you using drugs and smoking marijuana when you're not? I mean, your liberty's on the line, and you're saying, screw it, I'm going to use it anyway.
You know, there's no excuse for it, really.
Do you work?
Yes, I do.
What do you do?
Landscape.
How often do you work?
I try to get at least like 30 hours a week, but, you know, it varies with the weather and depending on what jobs we're doing.
Who do you work for?
Nature's Way.
Nature's what?
Nature's Way. It's in Chesterland.
Well, when you go to the probation department, you get to meet with them because they're going to conduct some interviews with you. They're going to administer some tests. First of all, it's important when you meet with them that you're open and honest with them. They're going to check and verify what you tell them. If they learn you're misleading them in any way, they're going to let me know that, and I'll consider that. Also, when you meet with them, they may request urine screens. You have to provide a urine sample. If you don't, your bond will be revoked. If you do and it comes back positive, your bond will be revoked and a warrant will be issued. You understand that?
Yes, Your Honor.
I mean, you're out on a personal bond, home reconnaissance bond, but there's conditions to follow. Seems like it'd be pretty simple that if I don't want to go to jail, I'm going to follow these conditions. You didn't do that. Now, when you leave here right now, you're going to go to the probation department, you're going to meet with them, sign some initial paperwork, fill out some initial paperwork, and get a date to come back for your interviews. Make sure you come back when you schedule those dates with them. If you don't, then they can't complete a pre-sentence report. Without a pre-sentence report, I can't consider probation as an option.
Okay.
And I won't continue the case to another day to get the pre-sentence report and interview done because it wasn't completed initially because you didn't show up when you were supposed to. You understand that?
Yes, sir.
So make sure you go there when you leave here right now.
All right.
Ms. Cutts, anything else for the record?
No, thank you, Your Honor.
Mr. Matthews?
No, Your Honor. Thank you.
Okie dokie, friends. Let's go back to Miami-Dade.
Split one bond counts for the cocaine and same with the cannabis.
So would you want to do 5,000 count one, 2,500 count two, 1,000 count three, $1 count four?
Well, count one is 5,000 because it's possession with intent to sell, but isn't the possession of cocaine included in the
Right,
intent
so the
to sell?
standard bond for possession with intent is 7,500. So the state's requesting that Your Honor split that
Okay,
7,500.
okay, 5,000 on count one, 2,500 on count two. And I know we're all tired, I know. Now, count three, how much cannabis?
It's cannabis, I'm okay with 1,000 for count three and then $1 on count four.
Or would you do $1 for each of the cannabis, Judge?
Up to you, Judge.
I'm gonna do $1 on the cannabis.
So that's 3 and 4?
It's less, yeah, it's less than 15 or small amount. Count three is $1, count four is $1. But he has a felony hold on F20 12044. So Jonathan Rivas. We're getting there.
Mr. Rivas is present. He speaks English.
Public defenders appointed. Okay. I'm looking for his priors. Do you show prior state?
Let me see.
I don't have the priors.
I have a DUI arrest out of state last year. I don't know how long he's been in Miami.
He's been here in Miami since January.
Right, so that arrest was from Georgia.
With whom do you live?
Who do you live with?
I live with myself and my mom, but my mom is always working. So.
He lives with his mom, Judge.
Are you working?
Yes, ma'am.
Where do you work?
I work for a cleaning maintenance company in a Brickell condominium during the daytime, and when I get off, I go to my second job at the 7-Eleven on 79th Street. I work overnight.
Okay, state, I don't have a priors, you said the only thing you see is a DUI?
That
Is
was
that-
in Georgia last year, and Ms. Corey indicated that the defendant's been in Miami since January. So Judge,
I'm
it's a track, he initially stopped, and then he shoved the officer, got into his car, and fled, weaving in and out of traffic at an excessive speed, and then subsequently ran on foot.
Okay, I'm gonna refer him to house arrest. And alternate on count one is. What is the
The
alternate on?
standard bond is 7,500.
Okay, 7,500 is the alternate on count one. The alternate on count two, which is battering a police officer, is
Standard is 5,000.
5,000.
And on count three, I think Ms. Corey, you raised the issue yesterday.
Right, there's nothing indicating serious bodily injury.
So
Except to
ROR
himself.
I don't believe that counts.
Yeah. Well, so on count three, it will be ROR. Count four is fleeing. I find probable cause for fleeing,
That's
and that,
incorporated in count one, Judge.
Can you do $1 on 4?
okay, $1.
And then count 5 is the resisting without. Standard is 500.
Count 5 is 500, alternate, and count 6,
Is
possession of
paraphernalia.
drug is $1. Okay,
What level was it, Judge? Level 2?
yes, level 2, so he can work and carry on. Tony Harris. Details.
He was released from prison on June 30th.
Of this year?
Yes.
I would ask for the TAP program for Mr. Harris.
On this case, count 1 is tab, alternate
Judge, he
bond.
did, if you look at his priors, he was sentenced to, what does it say? Where's the form? I saw 28 years in state prison.
28 years?
Maybe it's months, but
It can't be 28 years,
It
it's
looks like-
33.
get it done, it's right.
28
That's-
months. 28
Yeah.
months.
But he was released from prison June 30th. He's got a lot of priors, states objecting to TAP.
That's for a case from, looks like 2013.
Alternate bond is 2,500 and alternate bond is 2,500 on count 2. And Mr. Harris, I don't know if I'm wasting my time, but your record tells me that you are wasting your life. So start thinking for yourself.
It overstates.
A future court date for Mr. Harris? October 20th?
Sir,
Do
you
we-
need to be in court on October 20th at 9 a.m. in front of Judge De La O.
No, that would
And
be
that
Judge
is-
Hernandez, Judge.
I'm sorry.
Judge
Okay.
Hernandez.
And that is Judge Fernandez. 9 o'clock, October 20th of this year.
Do we have a courtroom number by any chance?
28, courtroom 28.
Thank you.
James Sims. This is a very serious charge where this defendant is alleged to have struck the victim with a gun. State, what is your request on this case?
Requesting the monetary bond. Standard bond count 1 is 7,500, 5,000 count 2, 500 count 3, 1,000 count 4.
I'm gonna require bond on count 1 of 7,500. And house arrest if he bonds out, plus house arrest. Level 2. Count 2 is assault with a firearm, which is pointing a gun at him. 5,000 is the alternate, is 5,000 is the bond plus house arrest. Count 3 is exhibition of the firearm is 500. And count 4 is battery, which is, what is battery, 500?
1,000.
Battery count 4 is 1,000. Sir, you have a no contact order, no contact with Norman Nicholas, and you are to stay away from the store, grab a snack, market at 1490 Northwest 71 Street. You cannot have contact with this person directly or through anybody else. You cannot call them, you cannot talk to them, you cannot have any direct communication or through social media. Do you understand the extent of the no contact order?
Yes.
Okay. Okay, the next case is Keith Bethia.
Bonded out, Your Honor.
Okay. Jimmy Hernandez.
Present, speaks English?
Do you speak English, sir?
Yes, Judge. Yes, Your Honor.
You're charged with having driving while your license is permanently revoked. And it is a $2,500 bond, and you're out on felony bond right now. And on that case is a felony hold 25-17408.
Judge, is that right? Can we just double check it? I will.
Okay.
Right.
Jose Berroa.
Okay, he's out on bond.
No, Jose Rodriguez Berroa.
He's on felony bond.
I'm sorry, one?
He's on felony bond.
Yes. Is this the defendant or we'll wait until?
Interpreter, please.
Gracias.
Public defender is appointed. He's charged assault with a deadly weapon. Is that he assaulted because of hitting her car with his car? Is that the charge?
Yes. And then also, he tried to run her over.
Oh my God. This is an extremely serious case, and I am going to, on count one, which is assault with a deadly
You
weapon.
need a Spanish interpreter. Why is it Spanish interpreter?
Do we have the Spanish interpreter here?
Let me re-promote. There's somebody else. One moment.
Okay, I'm sorry. I thought she was there. She got. Is it the
Yes.
7th?
Good afternoon, Your Honor, interpreter present.
Yes, hi. Have you been sworn this morning?
Yes, Your Honor, I have.
You have, thank you. Okay. If you can help with Mr. Rodriguez Berroa, he's charged with count one, assault with a deadly weapon, which was the car. What is the bond on that state?
5,000.
Count one is 5,000. Count two is
2,500.
aggravated.
Bien, señora, usted se le está acusando de agresión agravada con un arma mortal. En este caso es el auto, el carro. Le
On
están
that,
fijando
I'm gonna
la
require-
fianza de $5,000. Por la segunda acusación, que es agresión agravada, se está solicitando $2,500 de multa.
No, not a
I'm sorry.
fine, it's a bond.
I'm sorry, yes. Me equivoqué, no es una multa, es una fianza.
Count two, what is the state's request?
Judge, standard bond, if y'all know, would add house arrest to it. The standard bond on 2 is 2,500.
Count two, is 2,500, and I'm going to add to both of these charges house arrest plus house arrest.
Bien, en
Level
todo
two.
caso, para la segunda acusación, que es agresión, la fianza está siendo fijada en $2,500. En adición a ello, se está también aplicando orden de arresto domiciliario más orden de arresto domiciliario nivel 2.
And tampering with a witness, which was also the victim, is, what is the bond?
2,500.
Count three is 2,500 plus house arrest. And
Y también por haber tratado de manipular al testigo, que es la víctima en este caso, también se está fijando fianza en la cantidad de $2,500. Sería el tercer cargo, más arresto domiciliario.
and count four, criminal mischief.
I didn't
Is
see a
20
value. I'd ask you to set $150 bond.
Is there a value here, state?
No.
Okay, so the bond will be $150.
Y en cuanto a la cuarta acusación en su contra, que es conducta penal indebida, la fianza estaría siendo fijada en $150.
You are to have no contact whatsoever with the victim whose initials are JG.
Señor, usted no puede tener contacto de ningún tipo con la víctima que tiene como iniciales JG.
No contact means you
Okay.
cannot approach her indirectly or directly, or indirectly through anybody else.
Al referirse que no puede haber contacto, eso quiere decir que usted no puede tener contacto indirecto o directo o a través de una tercera persona.
Okay.
You cannot
Okay.
communicate with her or attempt to communicate with her through any medium, any writing or any electronic manner or any social media.
Y de la misma manera no puede comunicarse con la víctima, ya sea por escrito o de algún tipo de medio electrónico o a través de ninguna red social. No se puede comunicar con ella.
Okay, gracias.
Okay,
You're
thank
to
you.
stay away from Bachata's restaurant at 883 West 29th Street, and you have a hold on a felony case.
Usted tiene que permanecer alejado del restaurante. Your Honor, the name of the restaurant again?
Bachatas on 883 West 29th Street.
El nombre del restaurante que usted tiene que permanecer alejado se llama Bachatas. Está ubicado en el 883 West de la 29 calle y usted tiene también una retención por una acusación de delito mayor.
And there's a felony hold on case number 25-18452.
Y también tiene usted una retención por parte de un caso de delito mayor, caso número 25-18452.
Judge, what's the level of the house arrest?
Level 2.
I'm sorry, Judge?
Level 2, I'm sorry.
Thank you.
I don't know what else. 2,500. There we go. Okay, Ramon Ortiz.
Mr. Ortiz is present. He speaks English.
Okay, I'm trying to find this on the. We're on page 15. Okay. Mr. Ortiz, you're charged with burglary unoccupied and on case that's from September 17, and that is burglary to a business, and you're charged with burglary unoccupied also on September 1. Public defender is appointed. This defendant has an extensive history, 20 years, 9 years. Okay, let me go to the earlier case that ends in 444. I'm gonna require a bond on this case, which is burglary unoccupied. What is the standard bond?
2,500.
2,500.
What case number is that, Your Honor?
The case that ends in 0444. And then on case number that ends in 0443. What is the bond on that case?
Also 2,500.
It was an extensive amount of items that were
They only
stolen.
charged him with the burglary, they didn't charge the thefts.
You know, given the amount of items that were I am going to increase the bond on count 1 to 5,000. You are to stay away from 18425 Northwest 2nd Avenue and to stay away from Elegant Beauty Supply 18300 Northwest 2nd Avenue. Alejandro Izaguirre.
Alrighty, my friends, it is that time. We know that when it comes to justice being served properly, nobody has it aligned as well as Southern Ohio. They know that justice is best served in a dark, dank, weird-looking basement with Soviet-era lighting and carpet ripped right out of The Shining and the echoes of the dead and the flickering of light from behind the camera that you know is just torches, the occasional scream, all of these things that we love. I'm excited to announce that the waiting chair of eternal delay plays a little bit of a role in what I'm about to show you, because they're going to bring out a whole bunch of orange people to stand beside the chair. We don't usually see orange in the dungeon court, so that'll be a special treat. You know it, you love it. It is our Friday guilty pleasure. Ladies and gentlemen, let's finish off the last half hour of the show with Dungeon Court.
This is an OVI, and there is also a criminal matter too, a CRV case.
Couple child
Endangered
endangerments.
children.
Got a cash charity out of Iron, correct?
Yeah. 7,500.
That's correct.
It bound over or still there for preliminary?
No, it was about, you waived to the grand jury for a bond reduction to 7,500.
Okay.
It had been set at 20,000 and we lowered it.
Your Honor, we're going to recess the pre-trial. I think the state is going to recommend a recommendation that we with treatment, we're still, of course, has to put on the iron case, but right here, we'll reset the pre-trial on Hamilton's side.
Okay. And do you think he will be able to postpone, or that you can convince common pleas to let him out?
Judge, it was set at 20,000. We had a discussion what reason why he could post, and that number was suggested to me that he could post a 7,500.
Well, I had ordered that he sign a new OR bond of 2,500 plus paid the $1,000 bond that was forfeited before when he didn't appear. He missed the pretrial back in October 23. So.
Yeah, I wasn't aware of that, Judge, but Judge Waldo did explain it was up to you. Didn't get out yesterday. We had cases pending here and different things.
Take the bond that was set at iron. We could reset the pre-trial, release him to treatment with an ankle monitor. That's called the ankle monitor, Your Honor. He's open all that. We can have an assessment anyways here.
And let's see, when did he go into jail this time?
I'm sorry.
When did he go into the jail this time?
I was actually at Western Regional. They came and got, I was there for about almost a month.
Okay.
I think it was.
All right, so wouldn't do any good to do a urine screen today. He's been incarcerated for a month now.
I just went.
What's the charge in common pleas?
F4, a stolen vehicle, Judge. F4.
Is that a family member or?
No, sir, it's alleged to be a U-Haul that wasn't returned.
Okay. State take any position on the bond issue?
No, Your Honor.
Does he have any explanation why he went 2 years without coming to court on his case?
Your Honor, he just mentioned. Clean. And a long period of time. He has no explanation, except for his addiction.
Okay. Well, knowing how things work, is it being suggested that I be over, it could be a month before he gets indicted. Are you wanting to make this happen right away for the treatment? There's no way I would release him if he went immediately to treatment.
Oh, yes, immediately to treatment. We're not against the patient whatsoever.
All right, well, he was supposed to go to Bethesda back in the day. No, Taylor's not here, but
We do have somebody from Bethesda.
okay.
And there are no
Would you want, this is Lance Davis, he was supposed to go for an assessment back 2 years ago, almost exactly, it was August of 23. He never showed up. But he's wanting to go now.
Your Honor, sorry,
Go
I'll
ahead.
have to ask about that.
Okay. Let's let you work on that, and then we'll come back and decide what the circumstances would be if he gets to go to treatment. And probably a GPS monitor needs to be in place also. And there's none available right now, so. All right, we'll recall this later, so if you can check on that, if you need to talk to him, he's in the office.
Okay.
You're welcome.
State of Ohio versus Belinda Fuller, case number CRV 24624, CRV 31753.
Yes.
I guess you have to report by that.
She said she was not going to. All right, Ms. Fuller, your lawyer's going to counsel with you, then we'll recall you after that happens.
State of Ohio versus Michael Gibson, case number CRD 082990 A, B, and C, and CRB 08272 A and B. Michael Gibson.
Michael Gibson. Okay, Mr. Gibson, in these two cases, we got contributing to delinquency of a minor, 08272, 08-2990 was driving under suspension. And it looks like you missed some hearings, but I also see some information about, makes me think that you were incarcerated in West Virginia at one period of time?
Yes, sir.
Okay. When did you get out of incarceration?
2022.
Okay, so you just got arrested on the warrants then?
Yes, sir. I just got arrested last night.
Where are you living now?
I ain't good. Like, I went to prison in West Virginia and everything, and they posted, had a thing on me where they checked and see if I had anything else on me or anything, and they said I was free to go. Like, before you make parole and stuff over there, they check and see if you have any out-of-state detainers or anything like that.
Well, these are misdemeanor warrants, so they're only good in Ohio. They're not good in West Virginia.
Yes, sir. I didn't.
So your mistake was coming to Ohio.
Yes.
And then getting arrested. I mean, how'd you get stopped? How'd you get picked up?
I had an air freshener hanging off my rear mirror, and they said that was the reason for me pulling me over.
And then they found out you had a warrant.
Yes, sir. I apologize about it.
Are you working?
Yes, sir. I work out at Rich's Auto, Jerry Green's, and he owns the salvage yard. It's Fort Worth. I go out there and I help. I got 2 little boys. I got a 2-year-old and a 4-year-old. I live with my fiance.
He was never sentenced on the 08-2990.
Okay. Yeah, I see you filed something asking it to be dismissed back in 2011, and the court denied it.
Yes, sir.
And it looks like that copy of that entry was sent to you. Okay, so from my review of the file, you owe 10 hours of community service and a $100 fine on 08-272. And he was never adjudicated on 08-2990. So here's what I'm going to do. I'm going to sentence you to the weekend in jail. You can be released Sunday at 6 p.m. And that's going to take care of 08-272, and I'll dismiss 08-2990 based on your jail dates. Okay, that's all.
So when can we leave?
Sunday at 6 o'clock.
Sunday at 6 in the morning or
Evening, 6 p.m.
Ohio versus Jeffrey A. Coster. Case number CRA 25-531 and
So that is the 21st, September 21st. This is your case, preliminary hearing and pre-trial.
It is, Judge. We worked with this Aggie County case. It was reported he had a holdout for Champaign County, Ohio. Turned out that there is not a holdout. Champaign County, but there is a whole lot of Boyd County. Judge Barrett, there's such a big man in Raver, he's a combat veteran in Iraq, and we're trying to get him into treatment, but he's got to deal with the Boyd County situation. So I reached out, but that was something that I'm already go back and come please on the 22nd of October. We can get this on the 24th. Possibly.
And I gave him an OR bond, so this
Yes.
isn't holding him, it's up to Judge
I
Bowers.
told Judge Ballard that, so he's also, unfortunately, we resolved the one issue that's not on the
Okay. So it's Boyd County that's keeping it.
Boyd County, yeah, Ohio is good now, but yeah, the 24th, I'll be about 22nd. Hopefully, by then, we'll be treatment, will be orange.
October 24th will be the next hearings, preliminary hearing and pre-trials at 10 o'clock. Thank you. Yes.
Thank you.
Well, I think, does he still have to, is Judge Ballard going to handle the extradition, or how do you want to handle it?
Well, that's good. We didn't, we discussed it, might go to Judge Waller, because he's up, but I don't know.
We don't have anything on it here.
So we know. Apparently, the jail found out he has the police. His first time was everybody in Champaign County. That turned out not to be the case, but then I was over Wednesday, they found out, I guess, from the sheriff. Out of Boyd County, something popped up. I can make contact, see if they contact that door or something.
Okay, let me know if there's something
Yeah, they
changed.
said, okay, we see what you want to see here. Yeah, because I was from Boyd County on Wednesday, I think it's legit.
State of Ohio versus Richard Regal. CRD 25586 A and B.
So this is for arraignment. You're Richard Regal? How do you pronounce your last name? Regal. Regal. All right, Mr. Regal, you got 2 charges filed against you. Before I go over those with you, explain your rights. You have a right to remain silent. You don't have to say anything. If you choose to make statements, though, everything you're saying is on the record. It's being recorded. It can be used against you if you admit something about your case. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state of Ohio approve the charges filed against you beyond reasonable doubt. Do you understand those things? You got 2 charges, resisting arrest and disorderly conduct. The resisting alleges that on September the 18th, excuse me, in Union Township, you resisted or interfered with the lawful arrest of yourself. That's a second-degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. 586B alleges that you engaged in disorderly conduct on the same day and place by being voluntarily intoxicated in a public place and engaging in conduct that was offensive or caused other people to be annoyed or alarmed due to your intoxication. That's a 4th-degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. You understand the 2 charges? And do you have any questions before you enter a plea? How do you plead to these charges? Guilty means you're admitting the charges are true, and by doing that, you waive the right to have a trial and to have a lawyer. Do you understand that? Okay, is that what you want to do? Okay, I'm going to accept your plea. Do you have a report on this, Richard Regal?
I do. May I approach?
Yes, if you could just read it in the record, that would be.
on 9/18/2025, Sergeant Sisler, Chesapeake Patrolman Johnson, Ferguson, Ohio State Trooper Sergeant Trelka, Duncan, and I were dispatched to 28 Township Road 1038 in reference to an intoxicated male being aggressive and erratic. Patrolman Johnson and Ferguson arrived on scene first and made contact with the suspect, a male who was later identified as Richard Griggle. Sergeant Sisler, Sergeant Trelka, Trooper Duncan, and I arrived on scene approximately 5 minutes after Patrolman Johnson and Ferguson. Upon my arrival, I observed Richard being verbally aggressive toward Patrolman Johnson and not complying with the commands he was being given. Sergeant Sisler attempted to calm Richard down by conversing with him about what was wrong. Richard continued being erratic, speaking in cursive. Richard began positioning himself in fighting stance and also started taking shorts up. Richard appeared intoxicated and moved along his feet, stumbling multiple times. Richard began approaching me, stating, "You ain't got shit, I'll fuck you up." On multiple occasions, Richard would approach officers asking him about training. While speaking with Sergeant Sisler, Richard admitted to drinking wild turkey. Sergeant Sisler attempted to get Richard to allow insurance personnel to take him to a hospital to get him help. Richard refused, stating he was just mad at life. Sergeant Sisler advised Richard to place his hands behind his back because he was under arrest. When Sergeant Sisler and I attempted to place Richard in handcuffs, he began attempting to pull his arms away. Sergeant Sisler and I placed Richard on the ground and was able to get him restrained and handcuffed. Richard was then placed in the back of my patrol car while I went to speak with his wife about what happened prior to us arriving on scene. Richard's wife identified herself as Roberta Riggle. Roberta advised she got in the car with her husband, and he stated he had a couple shots of alcohol. Roberta stated Richard has not drank in months. Roberta advised Richard began to doze off, and she was not able to get him to respond to her. Roberta stated when she was unable to get Richard to respond, she called 911. Roberta advised while she was on the phone with 911, Richard woke up scared and began screaming. Roberta stated she attempted to calm Richard down, but was unable to do so. After speaking with Roberta, I returned to my vehicle and was informed that Richard had made threats toward Patrolman Johnson. While he was speaking with Patrolman Johnson, advised Richard stated, "I will fuck you up." After gathering all the information needed, I transported Richard to the Lawrence County Jail with no further incident.
Mr. Regal, anything you wish to say in explanation, or?
You know, with all due respect, I drank alcohol, and I have no right here. We've been up for before you and I'm trying to get back to the help that I was getting. The guy that I was with, he quit, and I just never got to get anybody else. It was my fault.
Where did you get it from?
Correct.
Okay. And do you have a medical card or health insurance?
Right now, I'm in between jobs. I just got hired on Marathon Patrolling in October 13th.
That's a good job.
But I have insurance through the state as of right now because I do have 3 kids, 3 boys.
Okay.
So we do get benefits from the state, so we do a lot.
What are you going to be doing in Marathon?
I'm going to be a tech camp, so I'll be working 28 days on, 28 days off. That's it. There's a crew in that. But I'll start my training October 13th, and then I will work 28 days, and then I'll be off for 10, just so that way I can take the information needed for training.
Okay, well, we need to get this under control, and it sounds like you were able to do that before.
Yes, sir.
Okay.
I got, like my wife stated and everything, I haven't been here for 4 months, and I haven't had a taste buds for it. I just happen to have
Okay. It looks like, just from the observation of this and your past history, that it's something you just have to forswear and say, I'm not going to go down that path anymore. And I think you're right to ask for help doing that. Okay, anything else you want to tell me?
No, sir, it's not.
Is the wife here? Any family members here?
She's with our 3 kids in the house. She could watch the kids. And I would like to add that I wasn't trying to fight any of the police officers. I wasn't pulling my shorts up or anything. I didn't want them to arrest me, but I was fortunately taken to the ground, and I got bruises all over my wrist, bruised
But usually when that happens, it's not the most pleasant experience.
Yeah, and I don't want to get into the he said, she said, so, you know, at the end of the day, I made a mistake out of it, and that's what it is.
Okay, on the resisting, I'm going to impose a $200 fine where you pay court costs. I'll give you 30 days in jail. I'll suspend, so you've been in a day, I'll suspend 29 days. I'm going to order that you go back to PROACT for substance use counseling. I'm going to order that you do 5 days of community service. You can do it on your days off when you're back in. I want you to keep the job with Marathon. I don't want to interfere with that. But you got to do this other stuff too. Do you know you're going to training on October the 13th? You know when you'll start your on board work?
Yeah, so typically you do 4 to 6 months training. Sometimes it could be a little bit sooner just because of the
Oh, so it's going to be a while before you're out in the park.
Yeah, it just depends on the individual and how quick they learn. Once they feel like you are independently, you can go out there by yourself and you do know on a march, then they'll send you. They've had some people go 2 months, they've had some people go 8 months. And, you know, they still got people that's been there a year because they just can't wrap their brain around some certain things.
Okay. Have you done this work before then, or?
I have not. I used to be a foreman for an asphalt company down in South Carolina, so.
Okay, I'm going to set your first review hearing for November the 7th. And what I want to see then is do some of your community service. I want to see that you're getting treated at PROACT and doing what they're setting up for you. So November the 7th at 9 o'clock will be your first review hearing, and that'll go on his entry. On the disorderly conduct, I'll just impose a $50 fine. Any questions?
You said something about 30 days in jail.
Suspend 29. So you're getting out of jail. But I got a month hanging over your head if you mess up. Yeah.
So you said 29 for 1 day that I spent last night, does that count?
Yeah.
Okay,
so you'll get out today, but you gotta go to treatment, and you gotta do community service, pay your fines and court costs.
I was trying to stay that proactive. The guy that I was seeing and the guy that I developed a good relationship with, he was no longer there.
Okay. Well, go back, I'm gonna order you to go back there. I'm sure they've got other people. If that doesn't work out, you can come back and I'll refer you someplace else.
Yes, sir.
That's all.
Judge says that's all, and he's right. That is all for this week, my friends. I hope you had fun. We got to see some interesting stuff. That first hearing from Lake County, Ohio was rather spirited. I did capture a clean copy of that, so that'll probably be a video this weekend, I would imagine. And we got to see some other fun stuff, too. And I will say, overall, I think this week was a much better week than the previous. So thank you all for that. Appreciate everybody's generosity today. Very cool of you. As always, your support just continues to amaze us, so thank you so much. We will be back tomorrow for game night, 8 p.m. Eastern, 5 p.m. Pacific. I think we're continuing with Lego Star Wars unless I come up with something better. Ashley says, happy anniversary, Dan and Mrs. TCF. Thank you so much for that. 17 years today. Feels like we just met yesterday. Feels like we've known each other forever. Kind of a little bit of both. Yeah. All right, so yeah, we'll be back tomorrow for game night, and then we'll be back for the morning show on Monday, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. If you're not a channel member, you should fix that so you can join us for the pre-show, plus get early access to the videos that we publish, a discount in our store, all sorts of fun stuff like that. But look forward to seeing you all, if not this weekend, for game night on Monday. Go have yourselves a great weekend. Take care. God bless.